I'm David Garvin, Florida Bar Board Certified Tax Attorney, concentrating on white-collar crime and tax defense for over 30 years. People ask me, when you learn that you are under an investigation, what steps should you take? And I tell them that speaking with the agents assigned to investigate the case is not a good idea. What they should do instead is tell the agents that they will get back to them once they have contacted an attorney. The issue then becomes what attorney to contact and who to retain. Well, it's very clear that there are a lot of very fine, qualified criminal attorneys who know how to conduct a federal criminal trial. And there are also a lot of very fine tax attorneys who know the Internal Revenue Code very well. The problem is that most criminal attorneys have no idea what is in the Internal Revenue Code and have no experience in defending people accused of violating the Internal Revenue Code. On the other hand, most tax attorneys that do know the Internal Revenue Code have very little experience with the tax sections in the code because they have never tried a criminal tax case, and they do not know the ins and outs of trying a jury trial in federal court. Sometimes the criminal attorney will tell the client that, don't worry, I will hire an expert, whether it's a CPA or a tax attorney, and we will team up, and working together we will cover both areas. Well, in a vacuum, this sounds like the solution to the problem, but in reality, it seldom works. I can give you an example why it doesn't work very well. In a typical trial, one of the most important witnesses will be the IRS agent. And that agent will have great familiarity with all the provisions of the Internal Revenue Code. When he is on the stand and he is about to be cross-examined by your criminal defense attorney, he realizes the criminal defense attorney has no idea what's in the Internal Revenue Code. And as a result, once the questioning starts, the answers turn into a filibuster type of speech, citing code sections and regulations and cases that he knows that the criminal attorney has no clue as to what he's talking about. This is a disaster. The jury starts to wonder whether defense has any credibility whatsoever. And even if the CPA or tax attorney that is part of the team is sitting at defense counsel next to you, he cannot get up and talk. And when the criminal attorney says to the judge, "Judge, may I have one moment to confer with my co-counsel and my client?" the judge will say, "Certainly, go ahead." The criminal attorney comes back and says to the tax attorney or CPA, "Is what he said true? What is he talking about?" And the tax attorney then says, "Well, I can definitely tell you, but it's going to take about 35 minutes, and that's if you're a fast learner." Well, by this time, the judge is getting impatient, the jury is getting restless, and the IRS agent is very smug, and the assistant United States attorney trying the case is more than confident. The judge starts banging his gavel and says, "Gentlemen, there's a jury trial going on here. Do you want to participate, or are you done with this witness?" And then, much to your surprise, the criminal attorney in frustration says, "No further questions." That does not increase your chances of prevailing. That does not result in you winning the case and preserving your liberty.